Mr. Zakowski.
Judge, we first call case number 24 on the calendar for Daniel Andre Thomas.
Good morning, Your Honor. Haley Collins on behalf of Mr. Thomas. He is present and approaching the podium to my right. And Your Honor, we're here for a violation of probation. I'm in receipt of a violation affidavit and waive formal reading. At this time, I will enter a denial. And for Your Honor's information, he does have another case pending in this division that has been filed on. I believe it's set for arraignment on January 27th.
Okay, let me take a look at the violation report. Is that the case underlying the new law violation allegation?
Yes, sir.
State making an offer at this time, Mr. Zakowski.
No, it's time, Judge.
Tell me that arraignment date again.
January 27th.
Your Honor, it's 21st.
Okay. All right. I'm just going to pass this case to the 21st, see if we can get them synced up.
Yes, sir. Thank you.
If the arraignment gets postponed, get an administrative pass for the appearance date on the violation of probation.
Yes, sir. Thank you.
Hey, Judge.
21st.
Your Honor, may I read the approach?
Yes.
Getting better.
Ms. James, would you approach, please?
Say Jameson?
James.
Oh,
Close, though. Council, we got to get this calendar moving. We've called one case in 23 minutes.
All right, I just alerted Mr. Brown, Mr. Benutti that both individuals are here, so we're just waiting on them to come back in. Not sure where they went.
Okay.
They said five minutes.
Morning, Your Honor.
Good morning.
Ashley Battey on behalf of the state. Maybe next call the case of Michael Small. He's number 23 on Your Honor.
Yes. Morning, Mr. Rosati.
Good morning, Your Honor. Good seeing you again. Mr. Small is present. Judge, we do have a proposed disposition for the court.
Okay.
Judge, this is Mr. Small. To my right, in case number 2023 CF 12872, at this time pursuant to negotiations with the state, not to confirm with my client, he's authorized me to withdraw his previously entered pleas of not guilty to counts 1 and 2 and 3 of the information and enter pleas of guilty to a lesser included offense as to each count: possession of fentanyl, possession of heroin, and possession of cocaine. So those first three would be lesser included offense, please. Those are all third-degree felonies, 5-year maximum, statutory felony maximum is $5,000. The proposed disposition is adjudicated guilty as to counts 1, 2, and 3. He'd be sentenced to 11 days Duval County jail credit for 11 days time served. Those sentences would run concurrently with each other. I believe it's $618 court cost, it's a $50 public defender application fee. The state has agreed to drop counts 4 and 5 of the information. My client and I have gone over this plea agreement, form the negotiated sentence. All parties have signed it. I've answered all those questions and I approach.
Yes. Please raise your right hand. Do you solemnly swear and affirm to tell the truth, and nothing but the truth, so help you God? Thank you.
Counsel, do either of you have the statutory size of the lesser included offenses?
893.13, subsection 6,
Is that for all of them?
yes, Your Honor.
Let's see, Ms. Potatoes, will this disposition be what you got?
It will, Your Honor.
Are you Michael Leonard Small Jr.? Yes, sir. Mr. Small, I have been given a document entitled plea of guilty with negotiated sentencing. On the last page of this document, there is a place for a defendant to sign. There's a signature there. It looks to me like that signature says Michael Small. Did you sign this in court today? Excuse me, did you have enough time to read that document yourself, go over it on your case, the guilty plea, and the negotiated sentence of Mr. Rosati? Yes, sir. Are you satisfied with his representation? Yes, sir. You understand that by signing this plea of guilty document, you're saying that you have read it, you understand it, and you read everything that it says? Yes, sir. You understand that today you are entering pleas of guilty to charges of possession of fentanyl, possession of heroin, possession of cocaine, all three of which are third-degree felonies. Understand that each one of those third-degree felonies will be punished by up to 5 years in prison. You understand that you have reached an agreement with the state to resolve your case by you being adjudicated guilty of those three third-degree felonies. The state will drop counts 4 and 5 that are pending against you. You'd be sentenced to 11 days in jail, credit for 11 days served. Within 9 days, you'll have to pay $618 in court costs. That includes $100 in the cost of prosecution and $100 in court department law enforcement fees. You will also have to pay $50 public defender application fees. That would understand to be the terms of your plea bargain. Mr. Rosati, is there any objection to that Florida Department of Law enforcement fee?
No, Your Honor.
Mr. Small, do you understand that by entering your guilty plea, you're giving up your right to continue to plead not guilty, as well as your right to have a jury trial, and the state would have to prove charges against you beyond a reasonable doubt?
Yes, sir.
You understand that you are also giving up the right to appeal all matters that relate to the judgment, and that includes the issue of guilt or innocence? Stipulations of counsel, my own review of those materials, I do find that there is an adequate factual basis for the entry of Mr. Small's guilty plea. I also find his guilty plea is entered freely, willingly, and voluntarily, with full understanding of the nature and consequences of doing so. Mr. Small will accept your guilty plea and sentence you according to that plea bargain. So I'm going to adjudicate you guilty to counts 1, 2, and 3, 3 felony offenses. Sentence you to 11 days in jail, credit for 11 days served. In 9 days, I'll pay that $618 for court costs and $50 public defender application fee. Do you understand your sentence?
Yes, sir.
You do have the right to appeal the legality of the sentence, but you have to file any appeals within 30 days. And if you can't afford an attorney for your appeal, one will be provided for you. Do you understand your appeal rights?
Yes, sir.
Let's see, state announcements.
Your Honor, City Council Noel Frost, code 30, counts 4 and 5, and will be providing the guidelines.
Thank you. Anything else in the defense, Mr. Rosati?
No, I will try to get remaining court dates in 30 seconds.
Sure. Mr. Small, you're going to be fingerprint, so otherwise I'm going to conclude the case.
Thank you very much, Your Honor. May I be excused?
Yes, thank you very much.
Good morning, our attorney for the Floyd being called Mario Berry, number 2 on the calendar.
Alyssa Floyd on behalf of Mr. Berry. He is not present, Your Honor. I'm waiting his appearance today. Mr. Berry has agreed to the state's CPC offer. Please on the Floyd receive trial argument sent to Mr. Martin. We're just asking for a month control date to make sure that that process goes through.
That's correct, Your Honor. I completed the paperwork for the bump down this morning, and also inquired if there was any other form I needed to complete. So hopefully I've done everything, and we could have it should have a county court date by the time we come back.
All right, let's come back on February 20, or let's pass to February 20. I hope we don't come back. All right.
And we can also call the case of Antoine Johnson, number 11 on the calendar.
Good morning, Judge.
Good morning, Mr. Gates.
For the record, Tyler Gates, Mr. Antoine Johnson, Judge, for the record, because his mom and girlfriend are present here before. It was on for a bond motion to be set that got added. He did not get transported.
Okay.
That certainly could have been my error. I don't know if I made it clear. He didn't know that he was in custody. He's on the out of custody list, but not the in custody, so he did not get brought over. That being said, we're asking to schedule a hearing. I would expect it to be, if we can't agree to a bond amount, I would say 15 minutes, probably 2 witnesses. It does sound like next week, based on the court schedule and the fact that the state is meeting with the victim, victim's family on Friday, the next week probably makes more sense.
All right. pretrial detention here?
Yeah, no, I believe so. Actually, Mr. Johnson was arrested, last week, I believe. And the case has not been filed yet. Like I said, I'm meeting with the victim on Friday. I see the charges and it's.
The F1.
Yes.
I think that's the list of crimes which you I have to double check.
I'm not sure if Mr. Johnson's age.
He's 20.
Okay.
It's just, bond is currently set at none, obviously there was none set at first appearance either.
Correct, yeah, it's a warrant. The bond was set on a warrant. Actually, it was by your honor, Judge, I think there's one that's on a warrant, actually.
More than likely, I would anticipate filing a lewd battery as opposed to a sexual battery. Parties involved.
Okay. Just to be clear, I would have signed that bond, no bond be set at first appearance.
Okay, yes, sir.
My reading of the current law is that's what is required for this charge.
Okay, yes, sir.
There's actually any ambiguity about that.
Yeah, I did not appear in the first appearance, so, yeah. If anything, you guys, that's fine.
Okay, so when did you want to come back to the case?
I mean, the court has availability, I know Monday's a holiday, Tuesday or Wednesday. I think this is one that could be in the calendar or during calendar, or certainly special set, whatever the court
We
said.
said 2 witnesses.
I would expect to have 2 witnesses. I'm also collecting letters, and I'll provide the state ahead of time, but also prepared to provide those to the court ahead of time as well.
Let's see, Ms. Martin, on the 23rd, I've got a willing to a child hearsay hearing in the Jones case. Is that your case?
Yes, it is, Your Honor.
We set it for 3:30 on the 23rd.
But that's acceptable to defense. Three 3:30 p.m. Yes, sir.
Mr. Martin, just to make sure the state understands, what I believe the new law requires is that absent a motion for pretrial detention, a bond will have to be set. No matter what the amount is.
Okay, sir.
Okay, thank you.
Thank you, sir. See you again. Yes. Thank you.
Okay.
Mr. Zakowski, what case would you like to call?
We have to call cases 15, 16, through 17 for Frederick Potts Jr.
Can I ask Mr. Pop one question?
Yes.
Thank you, Your Honor.
All right, Ms. Hinchy, so we are here for a final pretrial on 24 CF 3061, and then for a pretrial in Mr. Potts' other cases. Defense ready for trial?
Yes, we are ready for trial, Your Honor. I did just want to put on the record the negotiations that we engaged in.
Sure.
Mr. Potts had offered 13 months in Florida State Prison to resolve all 3 of his cases.
Right.
And the state did accept that offer. Mr. Potts' society does not wish to plead to the possession of a firearm as his felon.
Okay.
Which that's fine, but I have alerted him that he scores over 13 months any way you look at it. If he gets found not guilty on possession of a firearm by a convicted felon, he just got the credit card fraud and batteries, people still score close to 30 months. So I just want him to be very well aware, yes, the state has indicated they are not going to reach 13 months later.
Right.
This is his last chance, and if he does prevail, or he does not prevail, he's still looking at a lengthier prison sentence.
Okay.
That's correct, Judge.
All right. Well, let me discuss some things with the state and Mr. Potts. Is that correct, Mr. Zakowski? The state is willing to resolve all 3 of Mr. Potts' cases for 13 months in prison?
That's correct, Your Honor.
Okay. In my notes indicate a score, a global score of 27.225 months, is that correct? Or is it higher than that?
I think that score was prior to the battery being filed,
Okay.
so it might,
Need
what,
some-
I'm sorry.
Let me see if I have the global
I have
score.
those. The new global score is 67.9 points, which is 29.925 months.
29.925?
Correct, Judge.
Okay. Now, count one, in case number 24 CF 8061, possession of firearm with a felon, is that charge of actual or constructive possession?
Constructive, Judge.
Okay. Now, at a trial, would the state be seeking a jury finding of actual possession, or does the state contend that such a finding would not be evidence that you would present? Or have you decided yet?
Have not decided at this time.
Okay. So I don't know much about the facts of your case, Mr. Potts. Don't take anything I'm saying as a comment on the facts of your case. Most cases, I see the evidence at the same time the jury sees it. And of course, perhaps the most important thing is I don't decide whether that evidence has proven the charges against you beyond a reasonable doubt. The jury makes that decision. But you know, sometimes it's a surprise to the defendants that I don't really know a whole lot about the evidence until trial starts. So at final pretrial, particularly in a case like this, where the state is making a substantially below guidelines offer, I always make sure that you understand, for myself, exactly how this will all be conducted. So the charge of possession of firearm by a convicted felon, depending on how the evidence plays out, the state could ask me to send a verdict form to the jury that has an actual possession finding. If they, if the jury makes that finding, then that's a 3-year day-for-day minimum mandatory for which you are not game time eligible. Ms. Hinchy, based on what you know of the evidence, is that, do you think that the evidence might support the jury making such a finding?
No, so the evidence I've been provided is on the bill of the
Okay, so that's probably a pretty good argument there. But nevertheless, that's a second-degree felony, can be punished by up to 15 years in prison. In that case, you're facing a misdemeanor that can be punished by up to a year in jail. That still is going to leave your other 2 cases pending. Those are 2 third-degree felonies in 24 CF 8287, 1 third-degree felony in 24 CF 11930. Each one of those third-degree felonies can be punished by up to 5 years in prison. Now, for lack of a better term, the default setting in the sentencing statute is that if crimes are charged on the same information, then sentencing is concurrent. And the reality is most of the time that's how I sentence. If they're charged on separate information, then it's consecutive. Most of the time that's how I sentence. So there's an advantage to resolving all these cases now versus having separate trials. If you have separate trials, I'm pretty sure the state's going to be over here arguing for consecutive sentencing. Ms. Hinchy can argue for concurrent. That's absolutely correct. Ms. Hinchy, now it's the lowest permissible sentence. If we're only talking about case number 24 CF 8061, and Mr. Potts is found guilty of charge, you know what's the sentence at the end of that case? Would that be the 27 months?
I think so, because that was the first case we were writing,
Right.
I believe. I'm not positive, and I also neglected to say that the state did tell me he was eligible to be classified as a felony offender
Okay.
as well.
So if that were found to be the case, I would have discretion to double the maximum sentences?
Yes, sir.
All right. The point I want to talk with you in most detail about, Mr. Potts, is that lowest permissible sentence. So according to my notes, it would be a little over 27 months in prison. So if the jury were to find you guilty of counts 1 and 2, the lowest sentence I can give you is 27 months in prison, which is a little more than double what the state has offered to accept. The only way that I could give you less than that is if Ms. Hinchy has prove by a preponderance of the evidence that there's a legal basis for me to go below that lowest permissible sentence. And it can't just be anything, there's delineated things that can allow me to go under that. And she also has to convince me that that's the best sentencing option. So you get the burdens on the defendant in that procedure. So you've got to do two things. You've got to prove it and convince me to do it. Again, I don't know what facts are out there, but it's your burden, and it's a burden of proof and persuasion. Do you know of facts that could, at this time, essentially, that would prove a legal mitigating circumstance? So that's an uphill battle. All right. So that's part of the problem is the law that governs sentencing only gives me certain things I can go below that lowest permissible sentence for. It can't just be that, I feel bad or there's a bad circumstances. It's got to be specific things. Another thing I got to tell you, Mr. Potts, is if you do want to go to trial, that is your right. It's your absolute right to do that. It's also not held against you anyway. So I don't want you to take anything I said as a comment on your guilt or innocence, or be taken as I would somehow punish you for going to trial. That's not what this is about. It's just about making sure you're fully informed if you decide to reject or not make your offer, I guess, is probably exactly what's happening. The state's not offering it, we would accept it. All right. Hopefully that was helpful, Mr. Potts. Do you need some more time to talk about this with your lawyer? I can give you more time, Mr. Potts. It's a big decision. We can temporarily pass.
Okay.
All right.
I'm sorry.
Okay, it's a big decision.
I think we're going to dissolve the case.
Okay.
I just have to use it for.
We'll temporarily pass. I want him to make his own decision, have time to do it.
Yes, sir. Thank you.
All right.
Good morning, Your Honor. Board Adams for the state. We can next call the case of Floyd West, case number 25, volume page 13.
We are indeed, Your Honor. Judge Reed Harder, on behalf of Mr. West, who is present, approaching the podium to my right. Your Honor, the court may recall back on November 26th, Mr. West entered a plea as to all 5 counts of the information, with the understanding that he would receive a sentence of 42 months for state prison with credit for 106 days served. The court was kind enough to pass the case sometime in order for Mr. West to get some medical issues resolved and addressed in the meantime, and has presented himself to the court for a sentence this morning. He does also have a bag of medications to take in with him as far as trying to assist the jail and facilitate his medical needs.
You have those with him himself?
He is in the bag, right?
We'll talk about that in a minute. First thing I always do in these circumstances is review the plea bargain to make sure that everybody is in agreement with what I'm about to do.
Yes, sir.
So I previously accepted Mr. West's guilty plea. That was to 5 counts. Count 1 being second-degree felony possession of firearm by convicted felon. Third-degree, count 2 being third-degree felony possession with the sale of cannabis. Count 3 being second-degree felony possession of place with trafficking or manufacturing of controlled substance. Count 4, manufacturing, delivery of drug paraphernalia. Third-degree felony. Count 5, first degree misdemeanor possession of controlled substance paraphernalia. The plea bargain called for prison, credit for 106 days time served, concurrent on all counts, presumably that one doesn't say, presumably the misdemeanor time served, and adjudication of guilt on all counts, and then of course, statutory mandated court calls with the $100 court requirement law enforcement fee on top of that. Is that consistent with state's understanding of the plea bargain?
Yes, sir.
Is that consistent with defense understanding of the plea bargain?
It is, Judge.
Mr. West, is that consistent with your understanding of the plea bargain?
Yes, sir.
Okay, very good. So with that out of the way, state you agree with time served on the misdemeanor charge?
Yes, sir.
Okay. All right, so Mr. West, having previously accepted your plea of guilty, I will sentence you according to the terms of that plea bargain. So I will adjudicate you guilty of counts 1 through 5 in your case. On the misdemeanor charge, count 5, I'm just going to sentence you to time served, 106 days in jail, credit for 106 days already served. On counts 1 through 4, and this will be a concurrent sentence, I will adjudicate you guilty of those 4 felony charges, sentence you to 42 months in the state prison with credit for 106 days time served. Within 90 days of your release, you'll have to pay $618 in court costs. That includes $100 for court department law enforcement fees and $100 for cost of prosecution. You will also have to pay a $50 public defender application. Do you understand your sentence? All right. You do have the right to appeal the legality of that sentence, but any appeals have to be filed within 30 days. And if you can't afford an attorney for the appeal, one's going to be provided for you. Do you understand your appeal rights?
Yes.
Anything else from the statement?
Nothing to say.
Anything else from the defense?
That was Judge.
Mr. West, you will be fingerprinted. That will otherwise conclude your case. Officer Thomas, what can we do about that bag of medication?
Judge, I checked, about the medication, they gonna, just,
Okay. Excellent. All right, thank you.
Thank you, Judge. That's all I have. Any excuse?
Yes.
Thank you. Have a good day.
Yes.
Good morning, Your Honor. I'm for estimation on Mr. Short's behalf. Just looking for a penalty trial.
Yes.
I would let the court know a few things we are going to do to continue. One of the things I want the court to know is that the state is going to be referring him to the diversion program.
Okay.
That diversion. So, in light of that, we also waive speedy trial. I did speak to Mr. Short about that if the court wanted to inquire.
Well, I'll inquire about this continuance with the late speedy trial. Is that correct that the state intends to agree to a diversionary position?
That's right.
Mr. Short, you agreeable to strike the jury selection set for Monday so you can try to do this diversionary program? Yes, sir. Okay, I'll grant the defense motion to continue. And strike jury selection. When do you think that you'll have everything wrapped up?
Mr. Saban, along with him.
I would ask for a 1-month control date, Your Honor.
Come back on February 20. Hopefully they'll come back on February 20.
Yes, sir.
All right.
Thank you, sir. Thank you
Thank
very
you.
much. Good to see you.
All right, good to see you.
Thank you.
Mr. Brown.
If I can call the cases of Contreras Garrard and Marcel Johnson. Mr. Garrard's case is number 8. Mr. Johnson's cases are numbers 12 and 13.
Hey, good morning, Your Honor.
Good morning. Good morning. All right, so I have been informed that at least one party would be seeking to continue the trial.
Yes, Your Honor. Nicole Jameson on behalf of Mr. Garrard. There are two what I deem to be pressing motions before the court, and I defer to the court as to how Your Honor wants to address them, but we did file that motion to sever. That has been outstanding. I think if the court grants it, that would, by virtue of the court's ruling, continue Mr. Garrard beyond the 27th regardless, and then at that point, the state could decide if they are ready to proceed on Mr. Johnson's case. So we could certainly address it in that fashion. That is the more pressing motion from my perspective, simply because it dictates things related to trial strategy, trial preparation, how we're going to approach Mr. Garrard's defense will obviously vary depending on whether he's being tried with Mr. Johnson or separate from Mr. Johnson. That being said, the defense did file a separate motion to continue Mr. Garrard's trial based on the reasons delineated in a written motion. Specifically, we received an FDLE disclosure from the state of Florida. I believe it was last Thursday. That disclosure revealed that Mr. Garrard's DNA was excluded from the vehicle. That has certainly required, it's called into question several things with respect to some other material items related to the state of Florida's presentation of evidence. Specifically, I think there are still outstanding shell casing analysis pending with FDLE as a result of the DNA. Without getting too deep into the specifics of our defense strategy, we did consult with an independent expert. I've since submitted a motion to the court, an ex parte motion to authorize payment for that expert. And that expert, unfortunately, my conversation with him on Friday, he is unavailable for trial the 27th. He's in a week-long trial in Monroe County that was a predated commitment. Obviously, I didn't consult with him until Friday the 10th, so he could not make himself available. That being said, I do have availability for both of my defense experts this morning, one of which has been listed, and obviously the 10th expert who I consulted with has not yet been formally disclosed to the state, but I have discussed those events with Mr. Brown. I don't believe there's an objection from the state of Florida, at least with respect to the continuance. I'm sure Mr. Brown objects to a motion to sever.
All right, let's sort of piece that out one by one. Is the state still seeking strategy to finish jointly?
Yes, sir.
Okay. Now, the motion to continue filed on behalf of Mr. Garrard on January 12, 2025, states that it is unopposed. Is that correct?
That's correct, Your Honor, and the state would be asking to have both cases continued. I would ask that we reset the motion to sever. I have availability next week, but I'm available when the court does. The reason I don't want to reset today, I want to be able to reach out. If the court does grant it, I want to reach out to all of my witnesses and get all of their availability. But in addition, once Ms. Jameson's experts are finalized, I would then seek to take their depositions. So I have no opposition to the motion to continue. I would ask we do not reset it today if the court grants it, but that we do set the motion to sever whenever the court.
Okay. Mr. Renee, what is your client's position regarding a delay of the trial?
Yes, Your Honor. Based off the FDLE report that was sent last week, also 3 additional videos were sent last week. I am going to also be asking for an alternate motion to
everybody is at least in agreement on that. So I'm going to grant the motion to continue to strike the current set jury selection. We won't reset until a later time. So we'll pick a new trial date when everybody's had an opportunity to get a more realistic idea of when this case will be brought to trial. Now let's see, as far as severance, more of a hypothetical question at this point, Mr. Grau. If I were to grant the defense motion to sever, which defendant would the state seek to try first?
Off the top of my head right now, potentially Mr. Johnson, but I would need to speak with my IRS first before confirming.
Sure. Mr. Benuti, what is Mr. Johnson's position of the party separate trials versus a joint trial?
Your Honor, I understand that there were statements that Mr. Johnson made regarding Mr. Gerard, and that the issue I believe the court was those statements be prejudicial to Mr. Gerard's case. Our position on that is there may be a way where state could potentially redact statements made by Mr. Johnson. So at this point, it would be the defense's position that, as for now, we would also be in opposition of the motion to sever, but that could potentially change if we were to have a separate hearing on that.
Okay.
Judge, I don't know if you would allow me a brief response to that, or if you wanted to table it for another moment.
Well, I'll hear a little bit about it. I mean, I might be able to hear enough to make a decision today. If not,
Yes, sir.
We'll talk about it some more. Obviously, the initial determination of joint trials is within the state's discretion. They have chosen to file a joint charging document here. So, this is obviously before trial, so the question is, whether separate trial is necessary to promote fair determination of guilt or innocence. So,
Yes, sir.
Ms. Jameson, you have filed a motion to sever. Why don't you tell me why a separate trial is necessary to promote fair determination of guilt or innocence?
Thank you. Several reasons. First and foremost, I think all the parties can agree there is a Bruton issue in this case. Mr. Johnson gave a total of, I think, at least 3 separate law enforcement interviews during which he made statements. He gave at least 2 to 3 separate stories, some of which implicate my client, Mr. Gerard, some of which implicate myself, some of which implicate a party that law enforcement determined was ultimately not responsible, 2 individuals named Slim and Drop, who I think law enforcement were able to identify and determine that in fact that story was not true. So there's multiple statements given by Mr. Johnson. Additionally, he actually submitted a sworn affidavit to the state attorney's office, apparently on his own without his lawyer's involvement, recanting and exonerating my client in June of 2024. So we have probably, I would say it conservatively, maybe 5 different versions of events. Mr. Gerard, in his law enforcement interview, maintained his innocence, denied any involvement in this whatsoever. So the state has at least a very significant logistical problem in terms of how they are going to proceed in front of 2 separate juries dealing with these statements. I don't even think Mr. Grau can realistically give one opening unless he just commits to not discussing Mr. Johnson's statements whatsoever. I'm unaware of any legal theory under which Mr. Johnson's statements would be admissible before my client's jury. So his jury is not permitted to hear any of that information whatsoever. I think the risk of taint is significant there. Additionally, the evidence against Mr. Johnson is overwhelming, whereas the evidence against Mr. Gerard is very circumstantial at best. And so the risk that his jury is going to be prejudiced by a discussion of the evidence against Mr. Johnson, I think, is significant.
Let's be clear about a couple things, because a lot of times these joinder and severance issues start mixing apples and oranges together.
Yes, sir.
So when the defendants are joined for trial by charging document, that's one jury. The choice to impanel two juries is a matter of judicial economy. That's within the discretion of the trial court. That's a separate issue from severance in Georgia.
Yes, sir.
Obviously, if there's severance, you have two actions that will be tried separately. There's clearly two juries. So looking at Rule 3.152B, we're dealing with the before trial scenario. Mr. Crow, are you intending to offer statements made by Mr. Johnson against Mr. Gerard?
No, Your Honor, I'm intending to offer statements by Mr. Johnson against Mr. Johnson.
Okay.
Mr. Johnson makes statements that puts him in the vehicle where he knows who the shooter is. He does name who the shooter is eventually. So I would use those statements against Mr. Johnson. What the state would be asking for is to try them together, but with two jury panels.
Okay.
So that Mr. Johnson's jury can hear the name of who Mr. Johnson is saying was with him to kind of corroborate Mr. Johnson's own statements that he was there and he knows the shooter. He might be a little weird if the jury, if I redact and he says, yes, I was there and blank was the shooter. However, if there was one jury, I could potentially redact Mr. Gerard's name. Mr. Johnson's statements are only to be used against Mr. Johnson. I know I cannot bring in hearsay against Mr. Gerard's case. But the only thing in this case is Mr. Johnson's statements to detectives. So at that point, we could excuse Mr. Gerard's jury and those can be played. Other than that, that's the only evidence that would prejudice Mr. Gerard. In this case, Your Honor, there are 3 juvenile victims, so with 2 jury trials, they would have to testify twice. There are 2 witnesses that are, I would say, well, one's related to Mr. Johnson, but they're both friends to both defendants, so they're not going to be very friendly witnesses for the state. They would have to testify twice if this is severed. One of the witnesses is Mr. Johnson's grandmother, who lives in Pensacola. She would have to drive over and testify twice.
Okay, so I just want to be very clear procedurally. I just recently had to do kind of a deep dive into separate juries, severance. If you're talking about separate juries, that actually would be a severance. We would have 2 actions that would be tried at the same time. You would impanel 2 juries. Those juries would each hear slightly different evidence, but that's actually 2 actions, and it would be a granting of a severance. Now, you're making an argument that judicial economy merits trying these 2 actions at the same time for 2 juries, and you may very well be correct about that. But I just want to be clear, it would be a grant of the motion to sever, just not, sounds like not quite the same way, not the way you would particularly like to have it done.
Correct.
Okay.
Your Honor, I know I had prepared for the severance. I thought we were just doing the motion to continue today, though, but now that I'm kind of thinking over that, before Your Honor makes a ruling, if I could have even a week just to double check whether or not the state would prefer to just redact Mr. Gerard's name from the videos.
Right.
And then we could do just one.
Right. And that's one of the choices provided to you by Rule 2. All right, so I'm going to reserve ruling on the motion to sever.
Yes,
Y'all
sir.
have a better idea of how I'm looking at it, which may help you decide how you want to move forward. I'm granting, did you move to continue, Mr. Moody?
Yes, sir.
All right, I'm granting both defense motions to continue. And probably come back on 2 weeks. Going to give y'all enough time to sort through that, or would you like 3?
I'm fine with 2 weeks. I think there's some other outstanding motions I would be looking to ask the court to address at that time, just simply for purposes of narrowing down my trial preparation.
Your Honor, I'm back in with you on January 30th, so that would be 2 weeks and 2 days. Would that be fine? And only if that's okay with the defense.
I would rather come back on February 4th.
Oh, that's also fine.
All right, does that work for defense?
Yes, sir, I'm available that day.
Okay, let's come back on February 4th. Y'all have done a good job of working together to figure out at least what the issues are to present to me for resolution. So think about, you might be able to reach an agreement on how you want to move forward on the trial. If not, we'll set a
Yes, sir. Judge, the only other outstanding time-sensitive issue that I wanted to bring back to the court's attention, there's this pending matter of Your Honor granting, at least orally, in part and denying in part, our motion to unseal grand jury testimony.
Right.
You were waiting on the state's written response before you signed the order. I don't believe the order has yet been signed. Mr. Grau has submitted his written response as required. And the only reason I've labeled that time sensitive is we need time to order the transcript and have to go through JC. I have a proposed order, but I just noticed it was from the original submission, so it must have December 2024 on it.
I've got a bid.
Okay, great. May I approach?
Yes.
Thank you.
Your Honor, while that's being done, just so I can reach out to my witnesses, what month or two is Your Honor, if you come back for a report, what months would Your Honor potentially would like to set this so I can get availability for all of those months from all of my witnesses?
If we have separate juries and try these actions at the same time, how long do you expect the trial to take?
I would think we could, if jury selection takes more than a day, I think there's still a possibility we can get it done in a full week. The evidence is kind of, I slightly disagree with you on that. I think the evidence is somewhat straightforward. I think a lot of the evidence we might be able to stipulate to, and when it comes to civilian witnesses that might have longer process, I think that might only be 2 or 3 of them.
Well, you need at least a week.
And my bigger concern is that I think a day of jury selection is optimistic for 2, because aren't we talking 2 12-person panels with 10? Yes, so I think that might be optimistic to squeeze that into a full day, but.
So jury selection being 2 days, there's still a possibility with 3 full days we can get it done, but yes, there's always the risk of it might go right this week.
So I have, and I'd be happy for you all to tell me if you think this is too far out. I have 2 weeks set aside for a death penalty case that for a variety of different reasons is looking like it may not go. So I can set you April 7th.
I know this is not very good for the court. I'll be out of the country the weeks of the April 7th, 14th, and 21st.
Okay. What do you think about March 24th?
I'm available that week.
I have a jury trial with Judge Burrell the week before, but I think there's a chance, 50-50 chance that could go or that could go away. So since I'm out most of April, I think I can go.
I mean, based upon what you all are telling me about discovery, that seems about as soon as you'd be ready. Is that a fair assessment?
Yes, sir. I mean, certainly if the court said it earlier, we would do our best to get there.
I'd rather set it one time with enough time.
Understood. I think that is more than sufficient, and
But that's what we're
confident the defense will be ready.
I just still need to reach out to all my
Sure.
witnesses.
I've just penciled it in. I'm not setting it for
Yes,
trial
sir.
that week. Discuss before we come back on the court whether that's an appropriate week.
And I'll just get availability for March, April, and May from all my witnesses.
I can avoid setting any sensitive matters for trial that week in the meantime.
Yes, sir.
Okay.
Your Honor, just so the court's aware, I do have a current trial set on the 24th,
Okay.
but I will get with Mr. Brown and Mr. Jason. Public trial dates potentially.
I could possibly reach you the 10th. The odds are not as good as the 24th.
Your Honor, I'm also in a second degree murder trial that I'm going to do as well, so.
Okay, we'll give it some thought.
Yes, sir.
All right, I'll see you on the 4th.
Thank you, Judge. That's all I have. Maybe excuse.
You may.
Thank you.
Morning.